I'm Nick Elliott. Obviously, a lot of people on the call I already know, but if you don't, I head our dispute resolution and employment group, and I sit as part of the employment team. You'll meet the rest of the team in a second, but we're really excited to be presenting on the topic of managing sickness absence today. For those that don't know Actons, we're a firm based out of Nottingham. We have one office there, and we service the whole of the UK. In terms of our client base, we work with local SMEs as well as a number of household names, some of which you might have spotted on the slide previously. And the wonderful team is there. You'll get to hear from James and Laura in just a second. In terms of other services we provide, we also do cover a full range of commercial services and private client services, and that includes things like corporate and commercial work, property, real estate, dispute resolution, as well as wills, trusts, probate, and that kind of thing. So yeah, we've got the kind of full range of services that we're able to help clients with. But that's probably enough of an introduction to us. It's going to be quite a practical session, as in we're not going to just repeat the law to you. We're going to give you some practical tips for managing sickness absence. I'm going to share with you a little story about the longest period of sickness absence that I've ever had to help a client manage, and it was actually a lawyer. And this is what lawyers look like. For those of you who don't recognise the picture, it Suits, the popular Netflix series, and yeah, this was a financial institution. I won't name them, but they phoned up, and it was their first job that they'd asked me to help with. And they basically said, Nick, we've got a long-term sickness absence issue. And I thought, okay, great, that's my speciality. Fantastic. First job, we're going to be able to help you here. And I said, well, how long have you been off? And they said 19 years. And I said, I'm sorry, do you mean 19 months? And they said, no, 19 years. We forgot about him. And I thought, okay, well, this isn't going quite as I'd planned. And essentially the story evolved, and they explained more detail to me. And essentially the lawyer in question had not been performing very well and had fallen out with his manager and had gone off sick with stress. And I think that had become depression. The manager had left. The HR team had changed and left. His file kind of got put away in a filing cabinet, as it was in those days, because this is a little while ago. And he basically went on to a permanent health insurance scheme, which means that he had 75% of his salary paid for 19 years. Until he walked into reception and said, I'd like to speak to somebody in the HR team, please, because I think we better bring this to an end. And they said, I'm sorry, we don't know who you are. And eventually they worked that out. And then they called us and they said, Nick, we'd like you to risk assess the situation. And I said, well, it's a bad situation because it's not going to play out very well when you explain to the employment tribunal judge, should this person bring a claim, that you forgot about your employee for 19 years. So that was an interesting one. I think it was even worse, and I had some sympathy for the individual at the point. We discovered that he hadn't told his family that he was off sick, and that he got up every day and put a suit on and walked out the door. And that was pretty shocking. But we did resolve it for the client, and they unsurprisingly came to a kind of amicable resolution with the individual, and all was well after that period of time. And of course, the people that were dealing with it at that point didn't even know who this person was and had not been involved in that kind of thing. So if anybody can beat that, please do put a longer period of sickness absence in the chat. I haven't found anybody yet, but hopefully that gives you some reassurance that actually some of the issues that you're dealing with may not be as serious as that, and we can put a positive spin on it in that way. But anyway, enough of me rabbiting on. Laura's going to talk us through some of the context and some of the legal backdrop to what we're talking about, and then we'll look at a few different elements to this. Laura.
Thanks. Morning, everyone. So as Nick's just said, I'm going to run through some of the background and the context to why we're having this webinar and sort of things we're going to talk about over the next hour or so. So in terms of the cost to business, obviously that's a massive thing that needs to be factored into decisions around sickness absence. So you'll see on the slide that sickness absence rates are the highest in a decade now. So over the last 10 years, they've really creeped up, and particularly since the pandemic. There's varied thoughts as to why it has shot up after the pandemic. various things such as, could it be that things were left untreated and that is now leading to more absence? Are people now less likely to battle through colds and flus at work that before the pandemic they would have gone in and cracked on with it? Or are people just generally more unwell after having COVID and is long COVID, which I think we'll touch on later on, causing there to be an increase in sickness absence? One of the other major contributors in the UK is the rise in mental health issues. So of the increased sickness absence rates in the UK, the largest increase was people taking time off for anxiety, depression, or any sort of mental health issue. And that is certainly something that employers are facing more and more often in our experience, and you guys might be seeing that too. Nick touched on the fact that I was going to give you the answer to the question earlier, so you all managed to get the right one. The running answer was correct. So the cost of absence sickness in the UK is around 20.6 billion, and you'll see it went up 3.7 billion in the last year. So I think that shows quite how rapidly the increase in sickness absence and the impact on the economy is. So in terms of the working time lost, there's a nice little map here, so you might be able to find where you are or where your employees are. For some of you, that will be looking all over the country, I appreciate. But it will give you an idea of whereabouts in the UK has the highest and the lowest. Here in the East Midlands, I think we're about joint lowest with London, so we're not doing too badly. So the context, and again, James and Nick will talk you through the claims in more detail in their own respective parts, but the background to this is unfair dismissal claims can obviously arise at any point once you've got the 2 years service. So looking at the fair reason, and we'll be talking you through how you identify the fair reason in a dismissal case, how that could interact with sickness absence. So if it's a capability, what do you need to look at? Or if it's actually just something that's a sickness absence is on the side of another fair reason, how that interacts. And you'll see here the medical advice and consultation with the employee. We'll be talking you through that in a lot more detail, but I think you'll get bored of us sounding like broken records saying, please keep talking to your employees. That is really important. And then the other one, which I think most of you will have alarm bells of as soon as you have someone that is off sick for a long period of time, is the disability discrimination angle. So you'll probably be quite familiar with the idea of indirect and direct discrimination, which you probably have heard bandied about at various employment law things over time. So direct discrimination is where there's less favourable treatment of an employee because of their disability. So a perhaps silly example could be somebody's come and said, I'm going to be off sick because I've got this disability, and your instant reaction is, well, I'm not dealing with that, so goodbye, you're out the door. That would be an example of direct. Not that I think that any of you are going to go and do that, and certainly wouldn't recommend it. And indirect is where the employee is put at a disadvantage because of a provision, criteria, or practice, which is essentially a rule or a policy, something that you have in your organisation that could lead to a disadvantage to people with a disability. So it's most commonly things like a sickness absence policy that has criteria for warnings at certain levels of absence. The two most common types of claims that arise from sickness absence are unfavourable treatment, so arising from a disability, and reasonable adjustments. So in the context of you having that policy in place that says, for example, once you've been off for 10 days or more, you get a warning for being off too much in a certain period of time. There's an increased risk that leads to increased heightened risk of disability discrimination claims because of the link between somebody being off for a reason related to their disability and it making it more easy or quicker for them to hit those targets and those warning levels. I think the team will also briefly cover in their scenarios justification. So certain types of discrimination can be justified, which we will run you through. And that might be looking at things like reasonable adjustments. So considering what are the options, could we have a look at changing the policy? Could we take out reasons connected to a disability? How are we going to police that? How feasible is it to do so? So sickness versus disability, not every time that someone calls in or every sickness absence period that someone has will be a disability. we'd always recommend looking at the definition below, and it is a legal definition, not a medical definition. So a person has a disability if they have a physical or mental impairment, and that impairment has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. So of course, we're not expecting you all to sit down with a checkbook and go, right, well, we think it's this, so that's tick, and it might be that, so tick again. Take advice. If it's clearly not a disability, so it's someone phoning in saying, I've got a bit of a snuffle today, I'm not coming in, and that is a repeated thing, then don't treat it as such. But if there's doubt, so it could be something that is connected potentially to a disability or is a disability, we'd always recommend that you treat any sort of sickness absence on that basis as though it is a disability, and that just lowers the legal risk to you. So in terms of the next hour or so, in terms of us running through, we're going to be looking at some of the major problems. So the short-term persistent absence, long-term illness and absence, and other tricky issues that will arise. James, I'm going to hand over to you to look through some short-term persistent absence.
Thank you, Laura. Good morning, everyone. Yes, I'm going to talk about short-term persistent absence, and I think often short-term absence can be a trickier problem than long-term absence for a few reasons. One of them is just that it's often ignored until it becomes a bit of a problem. Another is that it's hard to predict often whether someone's attendance levels are going to improve or whether they'll improve, and if they are, why, and if they won't, why not. Sometimes it's difficult to discern whether there is an underlying cause for absences or the opposite, if there isn't one. And a common pitfall I've seen from employers is getting confused with somebody who just doesn't come to work that much because they're off, and people that are actually committing acts of misconduct. So they're not unwell, but they're calling in sick and they're spotted down the pub or on Facebook or in other such matters. But the purpose of this little section here is to do with short-term absences that are either genuine, or even if you as the employer might have suspicions that they're not genuine, we've got no reasonable basis to allege that they're not genuine. So we'll assume that they're genuine, even if we have suspicions. Absence procedures, that's already been touched on a couple of times. Now, in the context of short-term persistent absence, it might be that you're managing that via your normal capability procedure, which is fairly generic and follows a similar pattern to the ACAS code and talks about various meetings. Some of the larger organisations, or often unionised organisations or public sector organisations, have a sort of specific attendance policy that I'm sure some people on the webinar will be familiar with. And they usually contain attendance targets, or what a lot of people call trigger points, where if a person hits a certain number of days absence or a certain number of occasions of absence within a certain period of time, it triggers a meeting and potentially warnings up until the eventual point of dismissal. And Laura touched on that earlier, just in the context of reasonable adjustments, which I'll come back to. And as Laura said, we are going to be a bit of a broken record on the engagement with the employees piece, because it's the easy win here. But in short-term absence, it's of particular importance too. And in that context, what I mean is, often when somebody's been off for a day or so, it'll be easy to just do nothing about it. But I'm certainly a fan of return to work meetings or interviews, simply because sometimes they can be an easy win, a disincentive. People are so adverse to any form of confrontation. The prospect of just having a 10-minute meeting just to discuss why they're off might put people off taking the time off in the first place. The only sort of temper to that is a balancing act between creating sort of hostile working environment. I don't think you need to do that. I think that the two can be done together, and that you can have a sympathetic and considerate meeting, but nonetheless get a bit of information about why the person is off. Because generally speaking, information is your friend, and what might seem trivial at the time could actually be very useful down the road if the problem, or there is a problem, and then it escalates. So if we're managing short-term persistent absence, what do we do? Well, the first thing I suggest you try and do is identify the reasons for the absence, and the return to work meetings that I just alluded to are your first sort of layer of investigation. Although we're assuming that these absences are genuine, I use the term investigation loosely. And also it's a concept you'd all be familiar with from managing disciplinaries, and later on Nick will talk about it in the context of long-term absence. But what do I mean by identify the reasons? Look at not just what employees say at return to work interviews, look at self-certification forms, sick notes. All of those things will be useful in giving you a picture as to why the person is off, and leads nicely on to point number 2. Is there an underlying health condition? That can be something that, well, it's something that you will need to address when managing short-term persistent absence. It could lead you to explore whether you think there's a disability at play. It could be to help you understand why attendance levels are low, and is there anything you can do to actually work with the employee to solve the problem. There could be an easy win there by just talking to the employee on something that isn't a particularly big medical issue, but something that can be fixed. And then finally, medical information, is it necessary? In short-term absence, the context of why you want medical information is a bit different to the context that Nick's going to go on to for long-term absence. The case law says that in not every case, when you're managing short-term absence, even in ones that lead to dismissal, will it be necessary to get medical advice. However, I'd suggest that's probably the rare occasion, because you're going to want to try and satisfy yourself that A, there isn't a disability potentially, or C, that B, there's no underlying cause of all the unlinked absences. It might seem obvious to you, but then you're not a medical expert probably. So sometimes it's worth doing just to rule something out rather than rule anything in. Unfair dismissal. From my experience, it's quite rare for an employee to be dismissed because of persistent short-term absence. And I don't really know why that is. It might be that employers are nervous of doing it for risk of an unfair dismissal claim. As Laura mentioned earlier, the same principles apply for dismissing for this reason as they would for any other. Firstly, you need to establish what the fair reason is under the legislation. Now, short-term absence is a bit of a unique one, because there's been some debate over the years as to what the reason actually is. Is it capability? Especially in a situation where you're dismissing a person who's actually in work and isn't sick because they've had too much time off previously. So how could you say they're not capable of working if they are in work? And probably the leading authority on it has concluded that it usually won't be capability as the reason for dismissal in a short-term absence case, although you might argue it in the alternative. The way that the reason has best been framed, in my view, by the Court of Appeal was a failure to meet attendance targets or comply with an absence procedure. Those being two things that, however you frame it, would fall within the scope of the wonderful catch-all, some other substantial reason within the Employment Rights Act. I actually did a 2-day unfair dismissal claim about 4 or 5 years ago now in the Birmingham Employment Tribunal. And anyone who's been in the Birmingham Employment Tribunal might know there's one specific judge, and he did award me a bonus point for arguing my client's case of being under the some other substantial reason head. You don't get anything for these bonus points, and as far as I'm aware, there is only one judge who awards them, but I'm still keeping it as a badge of honour. And in that case, we were able to successfully establish that the claimant was fairly dismissed. The fact pattern was fairly common, really. We had in the bundle of documents 3 or 4 years worth of calendars, shall we say, with their absence marked on for every day, and each year there was about 20 odd days of absence spread over numerous periods, and we had a raft of sick notes, and they ranged from toothache to flu to cold to various accidents and ailments, and it was a complete mishmash of different things with no underlying cause, which then led the tribunal to consider the question of whether dismissing for persistent absence, which they had done, was reasonable or not. How did the tribunal decide that? Well, they applied the test that luckily at that point, and it's still the same now, I'm pleased to say, the case law had set out for us. And this is unique to the short-term absence scenario, so it won't apply to nicks or to dismissals for other reasons. And in summary, the points that Tribunal will consider are on the slide. So the expectation will be that for the dismissal to be fair, firstly, the employer will have fairly reviewed the pattern of absences with the employee and the reasons for them, doing the things I alluded to earlier, looking for an underlying cause, considering whether medical evidence is necessary. If it is, considering that and consulting with the employee as to what that medical evidence is. The second one shouldn't surprise anyone. It applies in the context of most areas of disciplinary type procedures or ACAS code compliant procedures, giving warnings. So it's not going to be fair to just have a 3 or 4 years worth of awful attendance and then have a meeting and dismiss for that reason. You will have need to have been working with the employee, giving warnings as to the problems they've got with their attendance. And that's easier done if you've got one of the policies I alluded to earlier, attendance policies that sets triggers and expectation levels. But that doesn't mean you can't do this if you don't have such a rigid policy. But it might mean you might need to engage with the employer a bit more about agreeing what are, and I say agreeing in a slightly loose sense, acceptable levels of attendance and acceptable time periods, with a view to then revisiting that after the relevant time has passed, with a view to improvement. And these are the sorts of warnings that should expire, because the idea of the process, if it's going to be fair, is that the person does improve. It shouldn't be a process aimed at getting them out. It should be one that aims at getting their attendance down, with the byproduct, if that doesn't happen, then it might lead to their dismissal. And as with any other type of dismissal, it shouldn't come as a surprise. So if you're inviting someone to a meeting which the outcome of which could be their employment being terminated, they should be told that, and it should be in writing. Otherwise, you're going to fall foul of the ACAS code of practice. And then finally, the last one, consider whether there is adequate improvement in attendance. Hopefully at that stage, if you're contemplating dismissal, it shouldn't be too difficult, because you'll have already set parameters. And I suppose the only time you're going to have a tricky situation is if there's some improvement, but not quite to the level you'd set. And then you've got a difficult decision as to whether or not you give them one more chance, or whether you take a final decision. But it's every case will be context dependent. Disability discrimination can be tricky in the situation where you're applying these absence triggers, as Laura alluded to. The two reasons: one, as Laura indicated, if you're applying absence triggers, then you are applying a provision, criterion, or practice. And if someone is disabled, it seems likely that they're going to be able to establish that their disability is going to mean they're more likely to be off sick, and then they're more likely to hit the triggers. So that brings in the two most common types of disability discrimination claim. The first is that they're being treated unfavourably because of something arising from their disability, the absence, or that we're under a duty to make reasonable adjustments because the policy, which is the provision or criterion or practice, puts them at a substantial disadvantage because of their disability. But you do need to look at this in the reverse context, and that's why I put the second bullet point: should disability-related absence be discounted? Because taken to the extreme, if you said that you couldn't apply absence policies and triggers to someone's disability-related absence, it could create a sort of perverse situation where they've just got an overwhelmingly high level of absence, and you're sort of restricted from doing anything about it. And the case law has helped us to a certain extent, although I still think these are some of the most difficult decisions you might have to make in any given case. The first thing is that you don't have to discount disability-related absences from managing absence. However, you should take into account that you are managing a disabled worker. So if you treat someone unfavourably by applying an absence trigger, it will only be discriminatory if you cannot justify that. And the justification defence is that you are taking proportionate steps to advance a legitimate aim. Now, in the short-term persistent absence context, the legitimate aim is quite easy to identify. It's ensuring the worker maintains a satisfactory level of attendance. The difficulty with justification defences is always proportionate, because proportionate is a judgment call. Where the case law helps us is that they provide a couple of suggested ways you could look at this. And the one I like is changing the context from, are they maintaining a reasonable level of absence as per the policy, to, are they maintaining a reasonable level of absence for someone with the disability that they have? So there's a nuance there, that you have to accept that people with disabilities are likely to be absent more, but there's a limit to that. And that's where medical advice may come in handy, in that you could seek medical advice asking, well, this person has these levels of absence. What would you ordinarily expect of someone with X condition? Is there anything we can do about it? And so you need to gather more information to satisfy yourself that you're taking steps that are proportionate, because it's unlikely that you will be taking proportionate steps if you aren't obtaining enough information in order to make your assessment as to whether you do issue absence warnings and ultimately dismiss employees. Similarly, with reasonable adjustments, it's unlikely to be a reasonable adjustment to just exempt disabled workers from attendance management, attendance policies, but it might be a reasonable adjustment to adjust the triggers to give them more tolerance on a similar basis that I just outlined with regard to employees who are likely to have higher levels of absence because of their specific disabilities. So those, I think, are probably two of the most tricky areas. There's no easy answer, and every person and case will be different. But I don't think you should shy away from managing their absence, whilst it does need to be handled carefully to avoid potential claims. And that's it on the short-term absence piece. I'm going to pass over to Nick for long-term absence.
Thanks, James. I think Heidi's just popped a question in the chat, which will be picked up hopefully as part of the section that we're about to head into. So we're going to talk about occupational health advice and medical advice in a bit more detail. If I don't cover it, Heidi, then pop another comment in the chat and we'll pick that up. So long-term absence, slightly different to the section that James has been talking about in terms of short-term persistent absence. And as you might expect, it's a longer sustained period of absence that an employee might have, hopefully not 19 years, but we're talking probably 3 months plus. I would say most people start to get worried that somebody's not back in work. And we're going to talk through a bit of a methodology for dealing with this kind of absence. And lots of what I'm going to talk about is about balancing the needs of the business, the employer, the organization, and the needs of the individual. So obviously we have a duty of care to our employees to look after them. We want them in work, and clearly them performing well for our organization is really, really important, and that's what we're aiming for. And often we are consulted in situations where we've tried to get people back, and unfortunately it's often more about the need for them to leave the organization as opposed to getting them back. But actually, lots of this applies to properly managing the longer term absence in the hope that we can facilitate their return to work. So we're going to talk a lot about business need and the needs of the individual, but we're also, I think, at the outset, going to focus on the fact that it's important to risk assess these situations, I think, when you're looking to manage them. And there's a whole load of different factors that you might be looking at when you're assessing what we're going to do about a long-term sickness absence. But I've added some of them to the slide there. Some of them are obvious, like how long is the absence, how long has the person been off, how serious is the illness that they're suffering with, what medical advice do we have, and we're going to look at how we get good medical advice a bit later. Have we considered any adjustments yet? Have any of those adjustments been put in place in order to try and help them return to work and do their job properly? How have we dealt with other situations where someone might have been off for a similar thing, because actually treating people fairly and consistently might feature as part of this. And then we're also looking at legal and financial risk. So it is worth, I think, at these stages, keeping in mind the fact, as Laura set out at the beginning, that there are some risks involved in managing these situations. And it might be that if we eventually end up at the end of the process dismissing somebody, that they may have an unfair dismissal claim or a disability discrimination claim. And actually, we want to do the best we can to protect the organisation if that ends up being the situation. And as part of that, the financial risk is linked to what the employee earns, because a lot of these claims the main part of it will be loss of earnings. If someone's claiming that they've been unfairly dismissed or discriminated against, there is injury to feelings, which is compensation for hurt feelings as a result of the discrimination. But clearly that loss of earnings element is a factor in terms of us taking a view on the risk around that situation. So when we're then looking at this sort of methodology for dealing with these issues, there are effectively 3 strands that we look at in terms of managing them, and that a tribunal would want to see that we'd considered. One of those is consulting with the employee, and what that basically means is talking to them about stuff. So talking to them about their absence, talking to them about adjustments that they might think are appropriate, or that medical professionals think are appropriate, and talking to them about the medical advice, talking to them about how they feel, talking to them about when they think they might be well enough to return. And that level of engagement is often tricky when employees are off sick, because they're obviously not in the workplace, they're not as accessible. But we do need to be doing our best to try and keep in appropriate contact with people, and ensure that we're engaging with that consultation side of things. Almost always in these longer term sickness absence cases, medical advice is important, and we'll look at that in more detail as to the kind of medical professionals that we might involve and how we might improve the chances that we get good medical advice. But also, and I think often missed in this process, is this business need. So clearly someone being off sick has an impact on the organization. It has an impact on our ability to do whatever it is we do, make widgets or provide a service or whatever it would be. And people being off sick has an impact on that. And employment tribunals are not immune to that. They understand that actually businesses are trying to do business, and people being off sick isn't ideal, and that there is a cost to that. There is an impact on our ability to get work done. And it also has an impact on other people. So team members, that kind of thing, covering work will put additional pressure on other people. So that's important to remember, and I think to weave into the process that we're running, because it's an important factor in how we deal with someone's absence, and we'll talk a bit more detail about that. Medical advice is a biggie in this area, and as the poll suggested at the beginning, without criticizing any medics that might be on the call, or people who are friendly with medics or married to medics, and I have to be careful because I've got myself into trouble with this. Both my parents worked in the NHS, so I can say that they do a cracking job. Often when it comes to these employment situations, we struggle to get good medical advice, and things like the person will be off for the foreseeable future don't help us. Anyone who's had a medical report for a long-term sickness absence may well have heard that phrase, and of course it gives no certainty whatsoever to an employer trying to manage these situations, because we don't know how long the foreseeable future will be. So it is important, I think, to consider which medical professional you go to. And again, I had a bit of a discussion, we use the polite term, on LinkedIn on a sickness absence post that I posted, where I think some people who were occupational health providers were very keen to emphasize that it should always be occupational health that are involved. And clearly that is definitely a good way to go. They tend to be medical people who are familiar with the workplace as well as the medical issues, and therefore are well placed to provide advice to employers on that. However, for smaller employers, it may be that that's too costly an approach, and it might be that the most we can do is go to the GP, the person that's treating the individual, and ask them some questions about how we might support that person and what they're capable of doing, and that kind of thing. Sometimes in super complex cases, and we have had a few, with the greatest respect to occupational health practitioners, it may be that the issue medically is so complicated and so specialist that actually consulting an independent medical expert who is a specialist in that field and can comment on the things that we need them to comment on might be more appropriate. The challenge there is that that's often more expensive, because you're going to a very senior person who's a specialist in the field for a report and that can be costly. But of course, if it's a high risk situation, because we've risk assessed it, as I talked about earlier on, it might be appropriate to go down that route. The other thing that we might need to look at is employee consent for both their medical records to provide to the medical person that we're asking a view from, and also access to the report itself. And Laura, I think we'll touch on some of that a bit later. But essentially, we need to ask permission from our employees for these things. Sometimes they won't give permission if we've got a particularly difficult situation. And the employee's not really on side with the employer in terms of moving these things forward and cooperating. Maybe there's been a fallout, or it's a disciplinary or grievance situation, or whatever it might be. And it may be that they refuse these things. And I think the key there, really, as a tip for that situation, is if that situation arises, building an audit trail which shows that we tried to get consent to these things, to send them to a medical person, to get the medical report, so that we are then best informed in order to help manage the situation, is the key bit. If they then refuse, we can point out that we would have to take decisions in the absence of medical advice, and we'd prefer not to do that. But if they're not prepared to cooperate, then we will have to do that. And I think that's the best we can do in those situations often. And as long as we can show that we've tried, then that will help us. But that can get tricky. I certainly had a case, again, it was when I was on secondment with an HR team at a financial institution, where the employees sought to send us only the medical records that they wanted to send us, which of course skewed the view of the absence totally, because we didn't actually have the full picture. So sometimes that can get quite complicated. The other thing that I think is important when it comes to getting good medical advice is ensuring that the employer's side of the story is put across. So usually what happens when an employee goes to a medic is that they tell their story, and often that is from their perspective, unsurprisingly, but sometimes won't include the full picture as to what the employer has done already and why the person is off in the first place, what adjustments might have been made. And it certainly is unlikely to emphasize the business need part of the sort of three-strand process that I was talking about, where it's important for that medic to know the impact that the absence is having on the business as well as the individual. It's important for them to be clear on what their job is. So we might send them their job description so they can see what their role actually is about. And we're going to want to emphasize the duty of care that we feel to that employee to try and get them back to work. And we're going to want to set out in proper detail, from our perspective, the history of the situation. So often medical referral forms you may have used are a bit limited. They're a bit boxy, and you only have a certain amount of space. If that's the case and you can't properly get the situation across, I'd encourage you to attach a letter or a report that sets out your side of things as well, so that things are balanced properly, and we don't necessarily then just get a medical view which is entirely skewed by what the employee has told them. Because if we're honest, often employees will feel aggrieved by what their employer has done and the lack of support or whatever it might be that they perceive, and redressing that balance is sometimes helpful. The other thing that we might want to consider is whether that medic needs medical records. So again, often occupational health providers will be happy with a telephone call with the person, and will then produce a report on that basis. Now, if it's a particularly complex area and issue, my personal view is that that's probably not enough to be able to assess what's actually going on with that person. Sometimes it therefore may be appropriate for us to ask consent for medical records and get those sent to the medic, or at the very least in the referral letter to ask them whether they need that information in order to give you a proper report, and push that obligation onto them in terms of the the accuracy and the validity of their advice. So I think that's important. Certainly if it's a very complicated issue and you're going to a specialist medic, I would expect them to want to review all of the medical records so that they're giving a proper view, an informed view on what's happening. So that's worth keeping in mind. And then I suppose the biggest area where we help clients with medical referrals in order to get good medical advice with regards to longer term sickness absence is asking the right questions. So again, often we have a standard referral form, which maybe we'll talk about, you know, can you tell us what the person's suffering with, and can you tell us whether there are any adjustments that we can make, and that kind of thing. But actually, sometimes that's why we get these woolly answers back. And actually, we would encourage you to think really carefully about the business need, as well as what we need to know in order to properly manage the employee. And that might be, for example, that we are a business that has seasonal peaks. So retail is an obvious one, wherein, you know, December, Christmas trading period, or January sales, we're busier and we need everybody in work. So we might say we need everybody back for this period of time. The person's already been off for 6 months. And then we would ask questions which help nail down, I suppose, to a certain extent, the medic in terms of that timescale for return. So, for example, we might say, can you say with certainty that they'll be back within the next 2 months, in order that they will be able to fulfill what we need them to do in their role for the Christmas trading period? Now, in reality, if the medic can say, yes, absolutely, they will be, I can say that with certainty, then great, and hopefully they'll be back. However, my experience is that most medics won't say that with certainty, because it's very difficult for them to know. And as a result, you then have a medical opinion that says this person, having been off for an extended period of time, won't be back within the timescale that we need. And that's helpful for us in then saying, okay, we have that medical review which confirms that you're not going to be well enough to do what we need you to do. And then we're going to move through the process, which we'll come on to in a bit more detail. The other thing that is maybe a bit controversial, but we see on virtually every referral form, is the question around the definition of disability that Laura talked about earlier in the Equality Act. And often it will say, can you confirm that this person is disabled under the Equality Act? Now, I often suggest that people take that question off the referral form. And there's a number of reasons. It sounds a bit balmy, but actually there are a number of reasons for that. One is, will it actually change the way that you manage the situation? If the person's off sick, as Laura said, and there's a risk that they will be disabled, we think that it might be having that kind of impact, then actually we're probably going to need to manage it and consider reasonable adjustments. We're going to have to get medical advice. We're going to have to do all the things that we would do. And whether actually a medic has said, yes, we think they're disabled under the Equality Act or not, doesn't really make a difference to how we manage it, because we're going to need to try and get them back to work or manage them out of the organisation. The other thing that Laura pointed out was that it's actually a legal definition, not a medical definition. So asking a medic to answer a legal definition doesn't make a lot of sense. And often, actually, I've seen medics say that, well, actually, this is a legal definition and I'm not qualified to tell you, you know, whether this person meets that definition or not. And in reality, the only person that can is the employment judge when they decide the case as to whether that person qualifies under that definition or not. Even us as lawyers can give you an idea, but we can't say for certain that that person is disabled. That will be decided at an employment tribunal hearing at some point, should you be unfortunate enough to end up there. And if that does happen, then actually having a medic say, yes, this person is disabled, makes it more difficult to do what often is the first step in a disability discrimination claim, which is to dispute disability. So actually, if we're not sure that this person has a disability and qualifies under that definition, then the first thing that we can do when we're defending that employment tribunal claim is say we dispute the fact that that's the case and we want the tribunal to decide whether it's right or not. And obviously, if we have a medical report from our own medic saying, yes, they meet the definition, although it's a legal one, not a medical one, it does put us on the back foot. So it's worth thinking about that. I have actually argued it against our own occupational health report previously, and won on that point. But it's certainly worth considering whether that's actually necessary or not, given that we can now risk assess this situation a bit ourselves anyway. So we then have the medical advice, and that's that key point. We've looked at business need. What do we need? How soon do we need this person back? We're getting the medical advice. That's the second strand. We've got that. What do we do next? Well, we read the report. And I know that sounds a very obvious one, but sometimes that's missed and it's not done in enough detail. So actually, what is the report actually saying? And sometimes it won't be very good. And if that's the case, what I would encourage you to do as the employer is not just put up with the fact that you've got a not very good report. I think often it's just a case of going back and saying to the medical person, well, that doesn't make sense to us, or we'd like you to look again because this isn't clear, or it doesn't give us any certainty. And certainly challenging that medical advice so that you are properly informed is really, really important. And I think doing it with respect and with the right motive is definitely worth doing if it's not clear, because you are relying on that. You're often paying for a service, and you deserve to get something that's helpful. Once you've got the report and you're happy that you understand what it is, then talking to the employee about it is really important. So that consultation strand, the third strand, the business need, the medical advice, and the consultation. So talk to them about what does it say? Are there adjustments that we need to look at in order to help that person return or to properly do their job? And that again is probably a whole other session, but looking at that and saying, can we actually make these changes? Can we make these adjustments in order to help that person return, or not? And sometimes it won't be possible because of various reasons. The other thing I've got on the slide there is alternative roles. So an adjustment might be to move somebody into another role. It might be to, certainly if we get very far down the line where it's looking like it might be a dismissal, the tribunal will expect you to look across your entire business in order to decide whether there are other roles this person could have done that would match the adjustments that are necessary. And again, I acted for a very large car manufacturer on a number of cases along these lines where we had to search a lot of different areas across the business to try and find roles that might be possible for people to do. And sometimes they were redeployed into those, and sometimes that wasn't possible and they had to move on. And then as part of that analysis, that consultation, we're looking at, okay, well, is the return likely? Can the person come back, yes or no? Does it match that business need? And then we're taking the decision. Well, actually, no, unfortunately, it's not possible on this occasion. So we're going to move through a process a bit like a disciplinary or a dismissal process where we meet with them more formally and warn them that the outcome of that process might be their dismissal. Just a couple of other alternatives that we need to look at, some of which will be relevant to some of you, but maybe not others. One is ill health retirement. So if your pension scheme has an ill health retirement option, then sometimes in these situations, rather than dismissal, it might be appropriate to look at ill health retirement. Again, when I was on secondment, I spent a lot of time working with the pension trustees of their scheme who felt that there were too many people getting ill health retirement, and the sort of the definition or the criteria for getting ill health retirement wasn't being applied properly, and I helped them deal with that. It's certainly worth looking at if that applies. And the other one that some people will have, but actually a lot of businesses don't have these days, is a permanent health insurance scheme. And that's the kind of scheme that I described at the beginning with the guy that was off for 19 years. The reason that took, I suspect, as long a time as that was that he was getting 75% of his salary with an inflationary increase every year for that period of time. And actually, other than the insurance premium, it wasn't costing that employer anything. And that's tricky because actually it makes it more difficult to do the process that I've just described with a person who's on that scheme. In fact, there's cases which suggest it's almost impossible to dismiss somebody who's on a permanent health insurance scheme, which is why some businesses choose not to have them. But at the same time, if you have somebody who's very unwell and you want to support them, there's clearly benefit in that too. And then, therefore, in summary, we've talked, it's a bit of a whistle-stop tour, and obviously we have a limited amount of time. We do a full training session on this methodology where we can go into a bit more detail. But essentially, you're looking for good medical evidence. You're looking to consult with the employee, remembering that business need. And as we go, we're following a fair procedure. We're giving opportunity for the employee to think about things, to engage with us, to talk about those issues. We're recording all of those steps as we go, and that audit trail is massively important, as it is with most areas of employment law. But in reality, having that audit trail to show we've done our best to try and manage this situation, and we've looked at all of these strands is really important. And as I say, looking at those alternatives where they apply, be it alternative roles or ill health retirement and permanent health insurance, is also really important, just to make sure we don't trip ourselves up at the last hurdle. So I'm going to hand over to the other guys to look at some other tricky issues. I'll jump on for some of those as well. But I think James is going to take us through the first couple.
Yes, thanks, Nick. So other tricky issues, poor performance. Wouldn't make sense in the context of this seminar if that poor performance wasn't in some way linked to sickness, absence, or some kind of underlying health condition. So what do I mean? I mean, the risk of claims arising where you perhaps dismiss someone for poor performance and then they latterly claim, well, actually, it was all because of some underlying health condition or disability. If you haven't explored that underlying health condition or disability, then you could fall foul of unfair dismissal, or potentially, if it's a disability discrimination. So that's something to be wary of. And the good practice that we've been discussing about looking at underlying health conditions and managing absence should mean that you don't come a cropper in the poor performance context. And second bullet point is really a statement of voice. Don't jump to conclusions, as we explored in detail with Nick. We're not medical experts. You aren't expected to be, but what you are expected to be is open-minded and spot any obvious signs, and then take reasonable steps to gain greater knowledge from experts when evidence suggests you ought to be doing so. Otherwise, there's a risk that you'll be deemed to know things you don't know, or in an unfair dismissal context, it will be deemed that you haven't acted reasonably because a reasonable employer would have explored things further. And then disability discrimination, it's that arising from type of discrimination that's the most likely to apply here, where an employer will argue that their poor performance has arisen as a consequence of their disability, or maybe that their ability to meet targets is being impacted by their disability. And as always with arising from, there's a synergy with reasonable adjustments, because it could be if you've got targets, for example, then a reasonable adjustment might be adjusting those targets to take into account the disability, whether that's working at different times, adjusting deadlines. All I ever say about reasonable adjustments is that sometimes employers and employees make the same mistake on reasonable adjustments, and they, what I describe as, jump to the end. And an employee will often come to you and say, I demand the following reasonable adjustment, and sort of self-proclaim its reasonableness. But if you haven't gone through the thought process correctly, you can get into a bit of a tangle in either agreeing to something you shouldn't have agreed to, and that comes back to bite you down the line, or not agreeing to something you should have agreed to. And the way I always say to look at reasonable adjustments is go back to the beginning. What is the issue? So going back to my example, performance targets, does it put someone with a disability at a substantial disadvantage? Well, it might do, depending on if their disability means they can't work through things as quickly. And then the next step is, what adjustments could we make? And there's an obvious one, which is change the targets. But the last step is that step reasonable? And whether something's reasonable, you need to consider things like, does it solve the problem? Does it alleviate the disadvantage? How much does it cost? And look at a variety of factors. So it's best to work out what the disadvantage the person suffers is, then think about what you could do to resolve that, then consider whether it's reasonable. Employees are often very keen to ask for something that they want, but it might not be something that actually alleviates the disadvantage. So don't jump to the end. Work through the reasonable adjustments carefully, because what may or may not be a reasonable adjustment in one person's eyes might not be in your employer's eyes. So that's reasonable adjustments and poor performance. And the last slide, obesity, but we could add to that perhaps long COVID and other conditions. These are conditions that obesity and long COVID aren't deemed disabilities. There's only a few things that are deemed disability: cancer, HIV, and various ones to do with eyesight problems, and some others. But for any condition like obesity and long COVID, the easier thing to do is apply the test of disability that Laura and Nick both alluded to. So the focus should be on whether there's an impairment, physical or mental, and being less worried about some kind of precise medical diagnosis or word for that impairment. If they've got some kind of impairment, what's the impact? And obesity itself might be a bit of a red herring, in that one of the cases in the UK courts, which was always reported as being about disability, arguably wasn't really about disability. About obesity. It was about disability. it was a case named Walker, and although there was an argument about obesity not being a disability, what the tribunals ultimately found was he had a condition called functional overlay, which was a slightly strange sounding condition where potentially as a cause of his disability, he had lots of things wrong with him to do with his internal organs and his bones. And the impact of the conditions on his bones and his internal organs meant there were a number of things that he was impacted in terms of his day-to-day activities, and that was a substantial and long-term thing. So although obesity wasn't a disability, the impact of it effectively meant that he did have a disability because of the other ancillary problems it had caused. And the same analysis could be done to long COVID, because I suspect that the long COVID itself is going to have causes, but whether it has other knock-on effects, and you just need to less worry about medical diagnosis and more about if he has long COVID, what's that? How is that impacting him? Is it affecting his day-to-day activities? Is it long-term? And in terms of those definitions, they're some of the brilliant words we haven't used yet. So when I talk about substantial adverse effect, I mean something that's more than trivial. And when I mean long-term, I mean something that has lasted 12 months or is likely to. And when you're assessing whether something's likely to, the tribunal, it's a real gem of a tribunal analysis here, could well happen. So you need to be mindful of that, because clearly there's scope for a claimant to argue that something could well happen if they've been off 6, 7, 8 months, that it could well last 12. So when looking at conditions that are new or lesser known, it's certainly possible that they're disabilities, and you just need to apply the test step by step. Laura.
Thanks, James. So I think Nick alluded to GDPR and the access to medical records and stuff earlier in his part. So the General Data Protection Regulation, which is the acronym for GDPR, has changed things slightly in terms of what you need to have in your policies or your contracts to actually get the medical records and have those there. So if you haven't updated or refreshed policies and contracts in recent years, it might be worth looking at that and doing so. So prior to 2018, when GDPR came into force, employers could largely get away with a contractual provision that simply said, I consent to a medical examination or to provide medical records, and then the employer's part of it was, I'll keep it confidential. And that was essentially just a line in the contract that was a catch-all provision. Since GDPR came into force, whatever you have in place, so if it's in a contract or a policy, has to say what the lawful basis of processing is. So in sickness absence terms, it's usually things like, we would like to have access to your medical records because it establishes an entitlement to enhanced sick pay. So if you've got somebody that's off and you've got company sick pay and you need the further information for that, or as Nick said earlier, to seek medical or occupational health input for purposes of facilitating a return to work or assessing whether there's anything that needs to be, any reasonable adjustments that could be made to make that possible, etc. So contractual provisions as a whole, as I've said, the old style catch-all is no longer one that we'd recommend. A lot of people do still have contractual provisions in, and we still do put them in contracts that redraft, so you will have seen them if you've heard something from us recently. The reason behind that is it acts as a bit of a reminder to employees that actually it's in their contract. It says that they've consented to give you access to medical records or to go and speak to occupational health should you wish to, etc. And it puts that kind of note in the back of their mind that, okay, I've told them I'll do that, so maybe I will. Now, as Nick said, we obviously get employees that don't play ball with that and will say no. The contractual provision being there is quite a useful tool in being able to say to them, well, actually, if you have a look at your contract that's in there, we'd really quite like you to comply with us, please. And then you start to get into that difficult situation of, do you infer anything from anything where they refuse to do so? How does that interact with the wider processes? But obviously we could assist you on that if that was a consistent or a problem that you needed to look at. And the other thing to be aware of is the Access to Medical Reports Act that was always the underpinning act of legislation here hasn't been changed by GDPR. So your employees still do have to consent in writing. So if you've not got it anywhere and you don't ask for it in writing before you go ahead and refer to occupational health, etc., then that could become a problem. And if you've got that sort of contractual provision in, it's another one of those reminders that people do need to be seeing their contracts and signing it. They do need to be seeing policies and have them accessible. Otherwise, any sort of arguments that you might want to run in terms of they did consent, it's in there, would fall at the first hurdle. And then disciplinary and grievances, again, the team have touched on this as they've been going through. So non-attendance at meetings, it is a fairly common occurrence that during a disciplinary process, for example, someone decides that they're off sick. So they're off because it's work-related stress, or they're off for generic reasons at the point that they're invited to a process. There is case law that says that stress in and of itself isn't a disability. And the case law is quite hot on the fact that simply saying I'm stressed by it all is unlikely to meet the legal threshold and the definition of a disability. Of course, we still need to be mindful that that might play into people, particularly if they've got a history of anxiety or depression, and that stress could trigger and make it a long-term 12 months type of issue. But a simple I'm very stressed and can't come in is unlikely to meet the threshold at that point. Of course, as Nick said earlier, medical advice is the way to look at that. So actually getting some medical record or seeking some medical opinion on what the impact of any alleged disability or anything that they're saying is causing them not to be able to properly participate in a disciplinary or grievance process is. And sometimes continuing the procedure might help. So if you've got somebody that's saying that they're very anxious about it all and they're concerned because they've got all this looming over them, perhaps or sometimes employers do like to make the point, and we certainly run this argument many times, that it might be a good idea to try and alleviate some of that stress and that anxiety by carrying on with the process, seeing what trying to get that to a resolve and not letting it hang over their heads. So you'll see here I've put e.g. written representations. That is to do with linking it back to the medical advice in the point above. So if you've got medical advice or the employee is telling you that they can't participate in the normal manner, it's working with them to find a way that actually the process can continue, and making some adjustments where possible or where reasonable to do so. So allowing the employee to write in rather than sit down on a call, instead of pulling them into meetings and sitting down. Could you do it via a video call? Could it be via a Teams call, etc.? And then the running of concurrent processes. Something that often happens with where you've got a sickness, absence, or a disability involved is people get scared and put a holder on other ones because they're busy dealing with the sickness side of things. There's absolutely nothing to stop you running more than one process at once. So if you've got an absence management process that's ongoing, and then you've also got a disciplinary process or a grievance process, you absolutely can continue running them alongside each other. Of course, it's always a case-by-case basis, so there will be some situations where it's advisable to put the hold on one because it links in with another. So if you've got somebody that's saying, well, my grievance is to do with this, and actually I think it's linked to my disability, and that's linked to another process that you've got going on, you might want to separate them, but equally you might want to roll them together and deal with it at that point. It really does depend on the individual and the individual circumstances. And of course, if you're not certain, taking legal advice might help you to formulate a plan and a way out of that. There is always the option of running processes in people's absence. So again, not one that we would usually recommend, but again, could be appropriate in certain circumstances. And it's something that we can obviously talk you through and help with on a case-by-case basis. Pass over to Nick.
Thanks, Laura. We're just going to look at the last couple of tricky issues. Cancer, obviously very common situation for people and something that employers have to grapple with. James touched on it briefly earlier. This is automatically a disability in nearly every situation. I did have one case where the facts were slightly different and tried to argue it in front of an employment judge, and that didn't go at all well when I tried to suggest that it wasn't automatically a disability. So in most cases that would be the case. I think there's a couple of cases where there was some analysis of whether sort of pre-cancerous conditions also were automatically a disability or not. And I think again, the general view is that you can't really distinguish between those things, and they will be almost always automatically defined as a disability. That then obviously kicks in the requirements to make reasonable adjustments, and that might relate to sick pay, time off, phased returns, and part-time working. The size and the resources of the employer is obviously really important in a lot of these situations as well. And the bigger you are, and the more well-off you are perceived to be, the higher the standard that the tribunal will expect of you, essentially. And again, consistency in these situations, cancer may well be one of those issues that comes up more than once within the same employer, and therefore thinking about whether you have a policy, even if it's an informal policy, but sometimes a written policy as to how you will help support people who have cancer and what they will be entitled to, for example, in terms of sick pay, that kind of thing, is worth thinking about, so that you are consistent and that you don't necessarily end up with people arguing that they've been treated differently despite that. The other thing that often is forgotten is the effect or the impact on co-workers. So when people are off sick, when people may be unfortunate enough to have a terminal condition, it is definitely worth engaging with your teams that are impacted by that in a positive way, and ensuring that they're okay, essentially. And that they are supported through what can be a difficult time for them, dealing with the impact that cancer might be having on a colleague. So that's just one that's sometimes forgotten. Alcohol is another tricky issue, and again, one that employers sometimes grapple with, the kind of, is this a disability or not? And it's a bit like the obesity examples that James gave. Alcohol dependency in itself is not defined in the Equality Act as a disability, but the illnesses resulting from alcohol abuse or alcohol dependency might be. So, for example, if you suffered depression as a result of alcoholism, or liver disease, if it was very serious, might well have an impact on your ability to do day-to-day activities in the substantial and long-term ways that the guys have talked about. So it's possible that will be an issue, and could then result in somebody having a disability. And again, like the issue with cancer, supporting the employee through that as best you can, being seen to do that and fulfill your duty of care to them, is a good idea. You might decide that you have a policy on that too. And it's also the case, I think, sometimes that if it's not a disability and it is someone who's effectively got a conduct issue, so maybe turning up to work drunk, or those kind of things, that might be one way that you would address that issue, rather than necessarily thinking this is an absence issue or a disability issue. It could well be that you look at, okay, well, we've told you a number of times that you can't turn up to work drunk, or you can't drink at work, or those kind of things. Now, you would have to keep in mind that that person might have some sort of disability that they might try and rely on to push back on those processes, but it's certainly not us saying that you can't deal with misconduct issues that relate to alcohol. And clearly, in certain sectors, it's particularly important that people are not under the influence. Menopause came up in one of the questions. Not a surprise, on the basis that it's definitely a hot topic in the HR world at the minute. And I think unsurprisingly, it's a bit like some of the other issues that we talked about. So essentially, it's whether the symptoms of the menopause satisfy the definition of the disability. So in itself, it's not deemed as a disability, and it's really about the impact that menopause has on the specific person. And that's why there are cases both ways. So there are cases where someone has been found to be suffering symptoms of the menopause and as a result have a disability. And there are cases where people have suffered lesser symptoms and been found not to have a disability because it doesn't meet the definition that we've already talked about. So on that basis, it's decided on a case by case situation. But of course, as we've talked about, when we're risk assessing a situation, it may well be that we have to be mindful of the fact that it could be a disability. but also forgetting the legal side of things, clearly supporting your employee through that is an important thing to do. So actually, taking account of adjustments that might be necessary, whether they're as a result of a disability or not, will be important in terms of your duty as an employer more generally. The other thing that sometimes comes up when it comes to menopause is also that there are potential age or sex discrimination risks. So it's not just about disability discrimination in that area, and that's worth factoring in. And I think there'll be probably more claims in this area as things develop and awareness is raised, I think. So just to wrap us up, do fire any more questions into the chat if you have them, but it won't surprise you to hear that in terms of protecting your organization, things like having a good capability or absence policy is really important. Making sure that your employment contracts are up to date, as Laura said, including that the wording around the medical referral, and considering sick pay, whether you're just going to have statutory sick or an enhanced payment for sick leave. And then, as James was talking about, those good procedures, so triggers for short-term absence, if that's an issue that you have that's persistent. Looking at those return to work meetings that we've talked about, and upskilling managers to do those well, because if they are a tick box, often it will feel pointless. There is still an audit trail being created, and I think there's value in that, but clearly engaging with the employee properly and understanding what's going on as part of those return to works is really important. Ensuring that sickness absence is reported and captured correctly is an important one as well. Often that's missed, where people aren't phoning in, or managers aren't passing on to a central HR system that people have even been off sick, and that obviously makes it difficult. And then obviously GDPR compliance, as Laura talked about, is important throughout the process to ensure that you're not tripping yourselves up on that front, and we're compliant all the way through. So, any questions? James, have you been monitoring as we go?
Yes, one of them's just jumped in, so let's have a look at that.
So Heidi says, do we need a separate policy for menopause? An employee has raised concerns over potential absence being related to menopause and has requested some dispensation as pregnant women that absence is discounted for disciplinary purposes.
Well, I suppose I could answer that. Do you need a separate policy? No, but that doesn't mean that it wouldn't be a good idea to have one. So, as with most policies, not compulsory, and this obvious advantage would be that you're more likely to get a consistent approach if you do have a policy. Should they get the same dispensation as pregnant women? Well, to a certain extent, that's largely up to you. If it's not a disability, and as Nick said, without more information, we couldn't tell if it was or it wasn't, then you're under no obligation to discount. But it might be reasonable to, especially if you factor in things like the length of service and the likelihood of the problem resolving. A lot of the problem times with absence issues, especially short-term ones, it's that you're managing it and attendance is bad and it's bad and it's bad and it's bad and it keeps going. If it's a new thing that pops up, chances are it'll resolve, hopefully, over time. So I suspect being more lenient would be the way to go. And there would need to be a wider context of horrific absence to be too upset about absences that have arisen recently after menopause, I would think.
Yeah. And then Leah has a message in, say, how short an absence spell would you suggest a return to work meeting would be necessary? So I think, again, there's no magic to that as such. I think if you could, you would probably have some sort of touch point with an employee after every absence, and that might be a formal return to work meeting, or it might be the manager, just talking to them, saying, hi, are you feeling better? And it may be that you document something as a result of that. I think Mark's noted that they do one for every day that they have off. I think there's no harm in having that audit trail. I think the practical issue often is whether actually there are managers free to have those conversations, and whether they're prepared to do that. But certainly capturing a record of why someone's been off, and that that there then being some sort of touch point after that to say, how you doing, are you feeling better, and getting any kind of information is helpful. I think particularly if it is a persistent issue, and of course having to have that chat, as James said earlier on, sometimes avoids it becoming a persistent issue. So lots of people commenting there, which is great. Any other questions? Anybody, feel free to unmute and fire a question at us if you'd like. Yeah, so for people asking about the slides and the recording, there is a recording of the session which will come out to everybody who signed up and attended. So that will be available. Yeah, go ahead.
Can I just ask a question? When you talked about the short-term reasons for dismissal, I sort of lost track a little bit. So you were talking about it being SOSR, but what's the most common one? Is it capability?
James, you want to pick that one up?
I probably should address that as soon as my section.
Sorry.
So no, if you're dismissing someone for lots of short-term absences, it's unlikely to be capability. It's likely to be because of poor attendance or a failure to hit targets in an absence policy. But that, to a certain extent, is more of a legal consideration when you're arguing a claim before the tribunal. When you're managing it on the ground, you just need to be clear with the employee as to why you're contemplating dismissing them. And if you're saying it's because you're not capable and they're sitting there going, but I'm fine, then it's quite a difficult conversation to have. Whereas if you're saying, I'm sure you would be, it's because your attendance levels over the last however long haven't been good enough, and or it's because we set these policy goals of you have so many days off and then you get this warning, or so many occasions of, and you haven't met the requirements of the attendance policy. That's the reason. So you just need to call a spade, and then the lawyers can sort out whether it's SOSR or capability when you file your response.
Okay, thank you.
Thanks, Ruth. Anybody else? Got one minute until the scheduled finish time, so we're happy to answer another question if there is one. Okay, nobody's jumping at the opportunity. That's no problem. So we'll just wrap up. For those that weren't on the call at the beginning, we are offering a few things at the minute. One is the free contract review for legal compliance, where we just prepare a short report, which basically highlights any gaps in your contracts that there might be, so you're aware of those. We are doing lots of training at the minute along the lines of these sessions, but in a lot more detail and tailored to your organisation. So if that's of interest, do let us know. If you happen to be in the East Midlands, we have something called the East Midlands HR Network, which I think Matt will pop a link to in the chat, and feel free to sign up to the mailing list there to make sure that you're aware of the events that we're putting on through the HR network. And as I mentioned earlier, we're really pleased that episode 5 of the HRD Talks podcast was released earlier this morning. If you're in any way interested in the world of work, which I'm sure most of you will be, please do have a listen. Let us know what you think. Share it with your friends, share it with your family, listen to it when you're walking the dog, whatever floats your boat. But we're really excited about that. We've still got a few more episodes in the can, as it were, to release, and the feedback so far has been really great. So hopefully that's useful for people. And again, there'll be a link to that, I think, in the chat. In fact, Matt's already put it there. So feel free to take a listen, and we would genuinely appreciate your feedback on that. And as we said at the beginning of our next webinar, we're taking a short summer break. Even employment lawyers need a rest sometimes, but we'll be back with TUPE for those that are interested in that subject in September, again helping you sort of manage the practical side of that, should it be relevant to your organisation. Thank you for all the thank yous, and yeah, we look forward to seeing everybody in September, and have a great summer break. Thanks everyone.